Hello, class. Welcome back. This is Contracts, LGLA 1351. This is Professor Watson, and we're getting close to the end of the semester. This is, I guess, week 14. We're on chapter 13 this week. And so this will be a very short lecture for this week. I understand that you guys have a lot of other things going on this week. We've got one more week, and then next week, check your assignments to make sure, but next week, our final exam is on Thursday. So I'll post a review next week. We'll talk about that at the end of this recording. But we're going to keep it short this week because I know you've got other stuff to do, but this is still officially a week for school. So good news, chapter 13 is very short, and it has to do with working with contracts. So let's take a look at that real quick. We'll go over that real briefly, and then we'll talk about how we're going to finish out the semester as far as reviewing for your final exam and that kind of stuff, okay? Let me see if I can share a PowerPoint here with you for this week. So this week in your book, I hope you've already looked through it. We're working with chapter 13 on working with contracts. This chapter is pretty self-explanatory. And quite frankly, there's not a whole lot in this chapter that is just that is law, right? This is really more practical discussions and suggestions about things to help you with contracts. There's nothing in this necessarily that's set in stone or that's absolute black and white, but they're suggestions. And so some semesters, if we're running late, for instance, this is an easy chapter to skip. Because a lot of it just makes sense. A lot of it is just basic. And if you really thought about it, you could come up with it on your own. So this is a great short chapter to cover here real quick at the end of the semester while you may have other things to do later this week, and while you're getting ready to start thinking about your final exam. All right. So here's the deal. There are as many different ways to draft contracts as there are contract drafters, right? Millions of ways. It's unlimited. It's like writing a book. And at the end of the day, exactly how you write your story or how you write your contract is really up to the author, right? In chapter 12, we discussed some general formatting to contracts, right? But that's in general. None of that was set in stone. Just like it generally makes sense for a book to have a title on the cover and a table of contents at the beginning of the book, it makes sense for a contract to identify the parties early on, or to have a section of definitions at the beginning, right? Signatures and notarizations and that kind of stuff at the end, definitions near the beginning. That makes sense. But there's no reason that says every book has to be drafted the same way, and there's nothing that says a contract has to be drafted the same way. Okay, but there are you'll see there are common forms, common styles that people use over and over again, and it just makes sense, right? So at the end of the day, what a contract looks like varies with the terms of what the purpose of the contract is, what kind of transaction this is. And also almost as much about who the author is, who the parties are drafting this contract. Okay. Now, you can always start drafting a contract from scratch. You can do that if you're a paralegal. Perhaps you shouldn't be giving people legal advice. Perhaps you shouldn't rely on just your own knowledge of the law if you are doing it for a client. But that doesn't mean you can't draft a contract from scratch for yourself or for some other reason, or for if you're being supervised by an attorney for them to review. And you're welcome to do that. But the question is, why? Why would you do that? I've been practicing law 25 years. I can't remember the last time I drafted a contract from scratch, because why would I do that, right? There's so many forms. There's no reason to reinvent the wheel. There's so many forms out there. There's so many other people who have drafted a contract that probably looks like something similar to what you're intending to do. That starting, whether you start from a form, some kind of published form, or whether you just start from some form that you've used before, or your law firm has used before, or your office has used before, often makes sense, right? Now that doesn't mean you can't tailor that and change that and edit it and amend it to be something that looks almost completely different from the form that you used last time, right? But it often makes sense to start from a form. I do it. Everybody does it. There's no reason really not to do it. Now, you want to be very careful though. Don't use a form or don't use something else you've used before and believe and just trust in that prior drafter, right? Whoever drafted that contract before, first of all, if it wasn't you, then you don't know for sure what's in it. Number two, whoever drafted that contract did not draft it for your specific circumstance. Okay, so even if you're using a form, and I highly recommend it, that's what I do. But even if you're using a form, whether it's again published or something you've done before, you've got to go back and check it. Read every line, see if there's anything that you need to change or amend to make it your own, to make it work for your situation. Okay. It is a good idea often to create a checklist of things that you need to have in your contract that you will be working with, okay? There are published checklists. There are any number of places where you can come up with a list of things that you might want or need in your contract. But just like you might make an outline for an essay or a book if you were writing one, you might outline a play or a movie if you were writing one. It's a good idea to begin at least with a checklist of the things, of the typical provisions that are in a contract, right? Do you need a signature and acknowledgement page? Sure. Do you need a definition page? Sure. But what about some other things like, do you need an arbitration provision? I don't know, maybe. Do you need an integration clause, right? Those kind of things. Maybe you don't need all those things, but if you at least start with kind of a basic checklist, it will help you remember the things that you might need, right? You would hate to get to the end and you've worked real hard and you've thought of 1,000 things, right? But because you were thinking so hard, because you got so much in this contract, you forgot to put in an integration clause, or you forgot to put in an arbitration clause. Maybe this would be a great contract for an arbitration clause, but you were doing so much other stuff that you didn't even think about it, right? And so these kind of checklists can help you just start with some of these basic provisions that we include in lots of contracts. And so use it kind of like a menu. Go through one of those checklists and pick and choose and make sure that you have all of those kind of standard parts that you need, right? All right, the second thing you probably need to do is to interview your client. Now, maybe you've already done this, but you need to sit down and go back over what is it the client wants and what is it the client needs, right? And don't just take their word for it. You need to dig in because that's why they're coming to you. If the clients knew everything they needed, if they could do it all on their own, they wouldn't need legal advice. And so make sure when you interview your clients, when you start considering their needs, you don't just listen to what they're telling you, but you dig deeper and you think about, what is their real issue? What is their goal? What are they trying to achieve? What do they think they need? What do they know they need? And what do they not know, but they actually need, right? So you need to figure out all those kind of things so that you can figure out what is the purpose of this contract? What are you trying to do with it before you begin drafting it, right? You should, of course, locate and become familiar with, are there any statutes or regulations that apply? We've talked time and time again this semester that in general, common law is typically where we find most contract law. And so the concepts of common law are generally applicable. But are there any special common law rules, or are there any special statutes that you need to be aware of that would apply to this contract that may affect the way you draft it, right? If you're drafting a lot of real estate contracts, for instance, or even if you're only drafting, even if this is the single real estate contract you've ever drafted, then you may want to be aware of some of those special statutes, right? Things like, of course, the statute of frauds, right? Remember that because it's a real estate contract, it has to be in writing. But maybe other statutes as well. If it's a residential contract, are there certain disclosures that you need to make? Are there certain provisions you need to include? If it's an employment contract, right? Are there specific statutes you need to consider, right? Is there a minimum wage statute? You don't want to have an employment contract with somebody where you agree to pay them $3 an hour, because that's going to be illegal, right? Or if you're going to have a non-compete clause, have you considered? Remember, we had a case brief on that this semester. I'm sorry, wrong class. Wrong class. No, I'm sorry, this is contracts. We had a briefing here on that. Remember, on enforceability of non-compete clauses in employment contracts, right? If you're going to have that, then you should be aware of those special rules and those special statutes to make sure that you are drafting those things correctly, right? Once you have started to gather this material, right, a list of our basic provisions, this idea of what our client wants and needs, what are their goals, right? What other things do I think they need? You've taken into consideration whether there's any extra statutes. Well, now it's time just to start moving things around on paper, right? To start plugging this into a system that makes sense, to begin to outline your contract. And of course, that just makes sense. And that's often where your contract starts to take this form that, again, is not required, but is very familiar, right? Where you identify parties at the beginning, and then maybe you have definitions, and then maybe you have a summary of consideration, right? And all of a sudden, as you start to organize these pieces, your contract starts to look a lot like other contracts that you've seen before. Number one, just because it makes sense. Number two, if that's a natural flow and it helps it be understandable. But number three, because that's where other people will be expecting to find things, right? And that makes it more understandable for them. Now, you may not be finished with the contract just because you know what your client needs and what your client would agree to. Remember, a contract always involves an agreement between two or more parties, right? So there's always another party. And at this point, now you can start negotiating, right? You can start negotiating with the other side to start fleshing this out. Your client has told you what they want and what they need. But maybe the other side doesn't have exactly the same picture, right? Maybe they're almost there and you just need to clarify a few things. Or maybe there's some real negotiating that needs to be done. If you've already got at least a draft or at least an outline of a contract in mind, that will help you with those negotiations, right? You can't just go into negotiations blind with absolutely no framework. Otherwise, you don't know what you need to negotiate, right? Do we need to negotiate price? Usually, right? But do you need to negotiate things like an arbitration provision? Do you need to negotiate things like a choice of law provision? If you haven't thought of those things, if you don't at least have some kind of framework, those things are easy to forget. And sometimes this negotiating and drafting process, once you start the negotiating, it can be an ongoing process, right? You draft a little, you negotiate a little. Then you revise your draft a little and send that to the other side, and they look at it and you negotiate a little. So this organizing and drafting and negotiating can then start to run together. Okay. When that happens, make sure that you start keeping records of all this, and two different types of records. Number one, you want to make sure that you're saving each of those drafts as you go. Make sure that you're saving those communications as you go, so that if there's a question later on, you've got some evidence of what was in the agreement, what the parties agreed to, when they agreed to it, right? Things that maybe you talked about but got thrown out. So for the sake of this negotiating in this contract, you should be keeping a historical file that shows all of the changes and the amendments in the negotiations. You should also maintain for yourself a separate form file. Okay, just do it. Keep your own form file, whether you're working for yourself, you're working in an office. It's easy to think that, well, I drafted one settlement agreement, right? Next time I need to draft a settlement agreement, I can go find that old client file. I'll pull up that settlement agreement and then I'll change it some for the next settlement agreement. Or I've drafted one employment contract or one home sales contract. And next time I need to draft another one, I'll just go find that one and then I can revise it. Well, that works, but it is not always the easiest way to find, right? A law practice can start to get very complicated as the weeks and months and years, and you get to be old like me and decades go by. sometimes it's hard to remember where that last settlement agreement was, or that last employment agreement was, or what the name of that client was, or maybe you changed law firms, right? Or maybe IT purged the old files. So it is a good idea to not only keep track of the various changes in the historical documents in the particular client file, but at least when you get to a final agreement, it's good to save a copy of that in a separate file where you keep all of the contracts that you've worked on, right? Or all of the significant, or at least examples of significant contracts that you have worked on just for your own career, just so that, like we just talked about a minute ago, you don't have to go back and reinvent the wheel every time. All right. Now, if you work at a title company, or you work at a real estate law firm, right, and you do real estate contracts all the time, you probably don't need to keep a copy of, in your own form file, you may not need to keep a copy of every single home sale contract that you drafted, right? If you've got one or two good examples, that's probably good enough. If you make some significant changes to one, or a new version comes out, or all of a sudden you think of something, you had a problem with an old one, and that occurred to you, you need to make a change next time. Maybe you update whatever your most recent form that you keep is, right? But in that kind of situation, you don't need to keep 1,000 copies of the same type of contract necessarily, but it doesn't hurt. Keeping your own form file as a resource can be very important to you and your career and your development. Keeping the client's file updated with all the updates and changes, and tracking the changes is very important to the client in the short term. Okay, so keeping those files, maintaining those files is important. What are the keys to drafting a good contract? Well, you may get different opinions on this from different drafters, right? I've told you that there's as many different types of contracts as there are problems to be negotiated, or deals to be negotiated, or people who draft them. So again, there's no absolute, form or plan for organizing a contract, but there are some general concepts that I think most people would agree to. Okay, at least based on my experience, these should be universal truths. Now, I understand. Last week, if you looked at our discussion last week, where we talked about that agreement between Stormy Daniels and Donald Trump, that contract violates half of these rules I'm about to tell you. And so are these universal truths? I think they are. I think if the people who drafted that contract had applied them to that contract, they would have drafted a better, probably more enforceable contract. But they're very expensive, very experienced lawyers, and they didn't seem to follow some of these rules. So, are they universal, or do they just make good sense? Again, that's probably up to you. If you're going to be drafting contracts, then you decide what you need your contract to look like. But in my experience, this is the very best advice I can give you for effective, efficient contracts that accomplish what the contract was meant to do and do not result in a bunch of tedious and unnecessary litigation. Okay. The biggest key to drafting a good contract is to make it organized and easy to read. Okay, organized and easy to read. Now, organized is part of easy to read, right? If you've got it in a logical format, then people know where to find things. That's part of being easy to read. But also the level that you're writing, the level of the language you use is part of being easy to read. When you look at your contract, when you start thinking of the words you use or the phrases you use, it's worth asking yourself, could a fifth grader understand this, right? Could a fifth grader understand this? Look back at that Donald Trump Stormy Daniels contract. I've still got a copy of it here on my desk right here, right? Remember this one? Did you read it? Did you read the whole thing? Or did you get bogged down? None of you are fifth graders. Did you understand every word in that contract? Does that make it a good contract? Did everybody understand what their obligations were? Did everybody understand what their duties were, what their liabilities might be if they breached the contract? Did everybody even understand what it would take to make that contract enforceable? I don't think so, right? That contract is more or less organized, but the language that it uses and just the grammar and the sentence structure, right, make it incredibly hard to understand. And so, think about it. Can a fifth grader understand this document? Can a fifth grader understand what the requirements are here? And think about that. It's not enough that you understand it. If something goes south, you have to end up in court. You're not the one who gets to make the decision. You may get the opportunity to explain what you thought it meant, but it's a judge or even a jury that is going to make the decision on what the contract actually meant or how the contract is going to be enforced. And that jury might be made up of a bunch of people who dropped out of school after the sixth grade. Okay, so draft your contract so that even a sixth grader could understand it. Keep it well organized. Keep related matters together. Okay. A good example is those definition sections, right? We talked about having a definition section, and when we talked about this, a week ago, I told you that a lot of times sometimes contracts don't have a definition section. It's just not that important. Or the contract is pretty simple. Or even if they do have a definition section, they may have a list of definitions. But then there might still be, words here and there that get defined in other places throughout the contract, like the parties, right? Take that Donald Trump Stormy Daniels contract. They defined the parties to be David Dennison, hereafter DD, right? That's a definition. Peggy Peterson, hereafter PP. That's a definition. And then they had that whole separate side agreement that defined Peggy Peterson to really mean Stephanie Clifford, aka Stormy Daniels. And that David Dennison really meant Donald Trump, right? Those are definitions. None of that appeared in the definition section. There's other definitions throughout that contract because that contract did not have a specific definition section. But even if a contract does have a definition section, people have a tendency, like I said, to pepper these definitions in other places throughout a contract. And if you do something like that, then first of all, you ought to think about, can I tighten that up? Can I pull those all back to one place? Can I keep those related items together? Okay. That also goes, though, to not just do I have parties and then recitals and then definitions and then, kind of the body of the contract, the consideration and the working parts together. But even in that kind of in the body section, am I keeping the pieces together? Like, what are Donald Trump's obligations? What are Stormy Daniels' obligations, right? What are ECLLC's obligations, if you remember that contract? That contract, the ECLLC's obligations were easy. They only had one. They had several sections that looked like they tried to group all of Stormy Daniels' obligations together not in one place, but in place after place after place after place. Remember, she had a ton of obligations. But what about Donald Trump's obligations, right? They were here and there and random and peppered throughout. And as a result, I think their lawyers forgot that Donald Trump had obligations or were supposed to have obligations under that contract. So remember, try to group things together. Try to go back and edit start with an outline. Start with an outline that makes sense to try to keep your sections together. Draft your contract, but then go back and edit it, review it, see if there's a better way to reorganize things to keep things together so that not only is the contract easier to understand, but it's easier to use, okay? So if you have a question, you can go grab that contract and turn to the part that you're looking for, or so the party can go turn to the part they're looking for because you've organized everything so well, okay? Good writing, like when you're writing briefs, right? Using signposts, using section headings and section numbering and section structure, right? Outline structure. Do you need that in every contract? Maybe not. But even if you're writing just a one-page, bill of sale for like a car, you can still use section headings. It just makes life easier. It keeps everything organized. It explains your organizing process, and it makes a contract easier to use. So section headings and paragraph numberings and an outline structure, very important to use for a contract, just because it makes the contract that much more efficient, that much easier to understand. Okay. If a contract is long enough, you may need to even consider having a table of contents or even an index. I see very few contracts with an index. A table of contents, maybe, but an index. But yes, maybe a complex construction contract. You may have boxes and boxes and boxes of attachments, plan diagrams and subcontracts, those kind of things. And so in some situations, yes, even an index. So your outline structure is important, section headings, that kind of stuff. And if necessary, even a table of contents, and even go as far as an index, okay, if that's what's necessary to make your contract easy to use. Try to, some things not to do. Try to avoid big blocks of texts and extremely long sentences, right? If this was an English class, a creative writing class, an essay writing class, of course, your writing professor would tell you to avoid run-on sentences. Why do they do that? Because they're difficult to read, right? Because they're difficult to keep track of. We use punctuation to help separate ideas. And if you can limit your sentence structure down to discrete thoughts and discrete ideas, limit big blocks of text, limit long run-on sentences, because just like in creative writing, it will make your contract easier to read, all right? If necessary, you don't have to write it in sentence form. You can break things up into subtopics or bullet points or even charts. You can use visuals and diagrams. If that makes your contract easier to understand, if that makes your contract more precise, then do that. But avoid, long blocks of text. Think of it like you all may be more familiar with these concepts these days because we're so much more electronic these days, right? Everything. When we design websites and Facebook pages and Twitter posts, right? We got to be short and to the point. We've got to grab people's attention. We got to make it easy for them to understand, easy for them to digest, or they'll move on, right? Do the same thing in your contracts. Keeps things short, keep things clear, keep things easy to understand. And if it begins to run on, if it begins to drone on, then break it up, okay? Break it up, go back and edit it, break it up, put it into discrete sections, digest it for the reader so that they don't have to go and graph out your contract themselves. Make it easy for them to understand. That way they know what they're required to do. They're less likely to breach the contract, right? They're more likely to know when they're breaching the contract. They're more likely to know what the downside will be if they breach the contract, okay? So keep them clear, concise, well-organized, well-written, okay? That leads us to that last point. Be sure that you're not only identifying obligations, but in the right context, make sure that you're thorough in identifying who has the obligations, which parties, which actors have which obligations, and what the consequences or remedies for breach will be, okay? Every required action in a contract every bit of consideration should identify the party required to take that action or give that consideration. The contract should address that action in great detail. The who, what's, when, whys, and hows, right? Of each obligation should be clear in the contract. I will pay, I'm going to buy your car for $500. Have we addressed all the who, what, when, where, and why? Well, we've got some of it. I am going to buy so who, what, your car. All right. For what? For $500. Okay, we got the what. But did we discuss the when or the where or the how? Am I going to buy your car for $500 today, Friday, next year? Are you going to deliver it, or are you going to drop it off at school? Do I have to come to your house? Do I need to pick it up in Mozambique? And how? Do I have to pick it up? Or are you going to ship it to me? sometimes even the why, right? We talked about those recitals sections, that sometimes identifying the why, the context for a contract, helps people may help a court later on, or help a jury, or help the parties understand what the purpose of a contract is for, and so what the language means. All right. So every time you have an obligation in a contract, make sure you are describing the who, what's, when, where's, and how's, right? Because you need that for every term. Don't just think, oh, well, we know because we're the ones drafting the contract. Yeah, you're not only drafting the contract for yourself. You're not only drafting the contract for the parties. You're drafting the contract in case a judge or a jury who's completely unaware of these negotiations. You're drafting the contract so that a judge or a jury can also understand it later on. Okay. Now, if you leave out some who's, what's, when's, where's, or why's, remember that the law can sometimes fill in details for a contract, right? Like we've discussed the time element, right? Under time is an essential element under a common law. But that sometimes a court will infer a reasonable time, especially remember when the UCC applies. The court will, the law will imply a reasonable time. So does that mean you can leave the time element out of your contract? Maybe that's in the best interest of your client, right? A reasonable time. But who's going to decide reasonable? It's not going to be your client. It's going to be a judge or a jury. So remember, if you leave elements out, the law may save you by implying terms, but it may not imply terms that you want. Okay, so you have to keep that in mind while you're drafting the contract too. All right. Whenever a contract provides that somebody should do something or not do something, right? Because remember, consideration can also be the giving up of a right. A consideration could be me giving you $500. Consideration could also be me agreeing that I'm giving up ever being able to sue you, right? A release. Anytime a contract states that somebody should do something like give up $500 or should give up doing something, should not do something like I won't sue you, the contract should also provide, it should be clear on what are the details if that person breaches. Okay. Now, in a simple contract, does that always need to be beat you over the head explicit? Not necessarily, right? With a one-page bill of sale for a car. I will sell you my car. I will buy your car for $500. You don't have to say, and if you don't pay me $500, then I can sue you for the $500 plus interest and attorney's fees, right? You probably don't need to include that in a simple contract like that. Why? Because we know all of that is already supplied by the law, okay? But in a longer contract, it is much better, it's much easier for the parties to understand if you start plugging that stuff in. Remember the UCC? The UCC, remember, is trying to facilitate contracts to make it easier for business people, for merchants to enter into contracts quickly without thinking about all these things, without hiring lawyers every time they want to draft a contract, or without hiring lawyers every time they think a contract has been breached. And how do they do that? Because the UCC provides a lot of this stuff on remedies. What's going to happen? What remedies do parties have if somebody breaches? But you may remember under common law, some of that was a grayer area, right? Like what if the other side you believe has anticipatorily breached the contract? Under the UCC, you would be an insecured party, right? And you could send the other side a demand saying, "Hey, we're going to need you to give us some kind of security here, right? Some kind of confidence that you're going to follow through. Otherwise, we're not entered into the contract." Under common law, that was harder, right? If you think the other side is going to breach, but they haven't breached yet, do you have to follow through on the contract? If you were supposed to pay first and then they were going to give you the car, but you think the car is long gone, what do? If you don't pay, then maybe you were in breach first because they didn't have to deliver the car yet. And the UCC doesn't apply if one of us isn't a merchant. So what do we do in that situation? The UCC would be great there, but the common law, not so much. That's a great thing to put into your contract if you think that far ahead. So making sure that people understand not only their obligations, but that they understand the ramifications and the consequences. They understand the remedies if they breach the contract. Can help the parties a great deal in two ways. Number one, it can encourage parties to go ahead and perform under a contract because they know what's expected of them and they know what's going to happen to them if they don't, right? Number two, though, it can help your client make a good business decision, right? When they've already drafted the contract, they say, well, something has changed and I might have to breach this contract, or I might have a choice. I've either got to breach this contract or I've got to breach this contract. Which one do I do? Well, if the remedies and the obligations are laid out very clearly, the consequences are laid out very clearly, then even if your client may be considering breaching the contract, that can help them make the better business decision, right? So maybe one effective way to, before you've completely buttoned up a contract, when you think you're down to a final draft, is then read through the contract, look at every single provision and ask yourself, what if this provision doesn't happen, right? If this provision doesn't happen, then what? Then what? And if you can't answer that from the contract itself or from just easy, black letter basic contract law, then you probably need to go back and put something else in the contract, okay? All right, moving on. Contracts must be internally consistent. A well-written contract never contains contradictory terms. And that may seem ridiculous, right? Of course, contracts are going to be consistent, but these days with so much cutting and pasting, right? I've already encouraged you to use forms and to use other contracts, to take an old contract and edit it and make it work in this new format. When you do so, you run the risk of creating internal inconsistencies. You run the risk of creating conflicts. And so you've got to be very careful to read over your contracts and make sure that, every time you use the term parties, you meant the parties, right? That every time you use the word dog, you meant dog. That's an example we've used before. If you define the term dog to mean cat, then you better look at that contract and make sure that every time you use the word dog, you meant cat. Every time you use the word buyer, you meant who? You meant the Mr. Smith. That every time you said seller, you meant who? You meant Mr. Watson. Whatever. So you got to make sure that those terms are internally consistent, and that just requires proofreading and attention to detail. It's about being meticulous, and somebody's got to do it. And if we have spent hours or days or even weeks or months drafting a contract, by the time we get something down on paper, it's easy to start losing focus. So remember, somebody needs to be meticulous and go through and check a contract to make sure that the terms you use are used in consistently the same way all the way through, even in that boilerplate stuff, even in that stuff that you're just copying and pasting from one contract over to another, right? Make sure that you didn't define buyer to mean one thing, and then later you cut and paste it in all your basic boilerplate language that you always put in, and it doesn't use buyer some way else, okay? Easy to get lost on that because you've read that boilerplate stuff 1,000 times. You know what it says, or at least you assume you know what it says. So easy to do, so easy for the lawyers you're working with to do. And so if you can help me by going through and proofreading one more time, by being meticulous about that kind of stuff, it can be extremely helpful, okay? Another thing you can do, and again, some of this is practical. How much money is this worth? How much time can your client pay for? How much can your client afford for you to look over this can sometimes be a limiting factor, okay? But ideally, if you have time, it's a good thing to try to read the contract, to put on your devil's advocate hat and try to read the contract from the other guy's side, right? If you were the other guy, is there something you could do to wriggle off the hook here? Is there some way you could take advantage of an inconsistency or a discrepancy or a hole in the contract? If you can, then you may need to go through and button those things up, okay? So if you can, try to read the contract, from the other side and see what this means to the other side, not just what it means to your client. Make sure, moving on, make sure that if you're using kind of an outline format, make sure that your numbering system or your organizing system for paragraphs and sections makes sense. That it makes sense, that it's consistent, and that your paragraph references remain correct. Okay, that's two different things. Number one, when you're using your word processor, you may be using an outline function to help keep track of that. That's great, because that way if you insert another section, it'll renumber everything for you, and you don't have to go back through and manually renumber everything. That can be great. But sometimes those things get off, right? Or sometimes they get tricky to manage, and you need to make sure that you're using those automatic numbering features effectively and correctly, and the computer has done what you meant to do. If you're not using those automatic numbering features, and I'm not going to say one way is best, because sometimes I like to use them because they make my life easier, and sometimes I don't. I just hand number things because it's gotten too tedious, or because it's just easier. But you got to be careful either way to make sure that it's consistent. And then again, check those internal references. If in paragraph 10, you say the consideration mentioned in the above paragraph 5 shall be due on December 1st, you better go back and make sure paragraph 5 is the consideration you're talking about. Because what if you are using that automatic numbering system? And what if somebody went in and inserted an extra paragraph 3, and now what you thought was paragraph 5 is now paragraph 6? So make sure those internal references to those section numbers stay good. Again, it's just proofreading and being meticulous and paying attention to detail. But it is so necessary, especially as a contract is going. It's one thing when you're drafting and you're adding a section, that kind of stuff. Sometimes that's easy to remember to go back and check your numbers. But when you're going through multiple drafts, especially if you're renegotiating during the process, right? You get it's easy to get so focused on the negotiating you're having and the changes you're making that you forget about what that does to the rest of the contract. Okay, so just again, be meticulous, pay attention to detail, look for consistency and clarity, right? That's really what all this boils down to. Again, make sure it's clear. I've already told you, draft it so that you think a fifth grader can understand it. But the bigger picture is that a contract should be understandable to the average person who is not there and doesn't have any idea what this contract is about. You should be able to take that contract to take it home, or take it to church, or take it to your poker game, and hand it to someone of your friends there, and they should be able to read it and understand at least the majority of what that contract is about and what its purpose is. And if they can't, then it's not a good contract, right? Because again, the parties may understand it, but what if something goes wrong? If something goes wrong, is a judge or a jury going to understand it? How is a judge or a jury going to understand it? And that's why you should make sure that a contract is easy to understand to the average person. You want an example? Again, I hate to keep going back to it. Take a look at that confidentiality agreement, that hush money contract between Donald Trump and Stormy Daniels. Ask yourself, was that easy to understand? And so, how do we know who breached it? Stormy Daniels says that Donald Trump breached it first. She says that Michael Cohen went around talking about it, that Donald Trump breached it first if it was even enforceable. They at one point said, no, she had breached it, and she breached it like 35 times in one weekend. So she owed them $35 million. Is that true? Is that what that meant? And you've read the text of that. What even did she do? It was so hard, so muddled to read, that contract was always going to end up in litigation. That's not a good contract. Make sure that the average person that you just hand this contract to out of the blue can understand it, can understand what it means, and most importantly, can understand what the parties are supposed to be doing. All right. Remember that right now, when you're drafting the contract, everything may be perfect. But you always hope for the best, but you always have to be preparing for the worst. Okay, so right now, the parties may be entering into this with the utmost in good faith. They may not only understand what their obligations are, they may be hoping to do this, right? That they're intended, they want to follow through on their part of the contract, but that's today while everything is good. And if everything always stayed good, then we may not even need lawyers and paralegals at all, right? We're drafting this contract in case something goes wrong. So be aware that the other side to a contract, at some point, they may be looking for any chance they've got to get out of a contract term, for any possible excuse to avoid that obligation. So you need to make sure it's clear what their obligations are, clear what they're required to do, clear what's going to happen if they don't do it, so that you don't give either side any wiggle room. Okay, and then, like I always said before, really test the contract by trying to put yourself in the shoes of the opposing party, right? Play devil's advocate, and try to figure out what you would do to get out of the contract if you were the other side. Have you given them a loophole? Have you given them an excuse? Now, again, if you're selling your car on Facebook and somebody's knocked on your door and you just need to draft a quick bill of sale, maybe you don't have time to do all this, right? But as the contracts become more and more important, as the obligations become more and more significant, then you need to do more and more of this, of making sure that the contract is understandable. Even in that context, though, even if you've just sold your car and you're going to sit down and type out a bill of sale in 5 minutes, it should be clear, right? If it's not clear, what's the use of drafting it? If you've only got 5 minutes, you want something crystal clear, because you really don't have time to negotiate it, right? So make sure that your contract is clear, easy to understand. All right. Now, think of it this way. Here's some of my final thoughts. These aren't necessarily in your book, but these are some final thoughts on being an effective paralegal, right? Part of the team in the contract drafting and negotiation. Okay. In the bigger picture, let's focus primarily on what your role is likely to be. Number one, remember that this is not creative writing. This is not, contracts aren't intended to be a good read. All right. You're not writing the great American novel. Think of it as you're writing a children's book, right? You do not need to use your thesaurus. You do not need to use a $10 word when a 10-cent word will do. You do not need to change words because you've already said the buyer too many times, right? Don't change it to the purchaser, the buyer, and then the purchaser, and then the person who wants to acquire the car. No, that's creative writing. Your creative writing teacher may tell you you've used this term too many times. Your contract professor will tell you, man, this just sounds like a Dr. Seuss book, right? Keep beating those same words over and over again to make it easy to understand, okay? So if you ever think that you have a need to start putting in language like the party of the first part, Professor Watson, hereafter referred to as the party of the first part, wishes to, purchase an automobile from seller, hereafter referred to as the party of the second part, because you've heard something like that in a TV show or a movie, or even read something like that in a contract. Fight the urge. It is completely unnecessary. Completely unnecessary. It doesn't make you look smart. It certainly doesn't make the contract any more enforceable. It just makes it harder to understand. And I'm completely serious when I tell you, if I ever find out that any of you have drafted a contract where you put in, quote, the party of the first part into a contract, if I find out, I'm going to go back, I'm going to file a change of grade request form 5 years from now, and I'm going to ask the dean to change your grade in this class to an F, because it is a preposterous thing to do. Do not ever try to put legalese in a contract. Don't ever try to make yourself look smart, because it's just not necessary. That's not the function of a contract, okay? Next, it's just, we've beat this point over and over and over again. Proofread, edit continuously. Every time you make a change, every time you open the document, you need to go back and look at the entire contract. If you make one little change, if you go in and you insert one little paragraph on page 47, you need to check everything above that to make sure you haven't changed anything. And you need to check everything below that to make sure that you understand what changes you've made to a contract. All right. You also need to make sure that you didn't miss anything last time. Okay. So proofread and edit, be meticulous continuously. Professionalism is really not about being that smart. Professionalism is about hard work. Okay. Hard work makes you look smart. It leads to clearer, conciser, better to understand contracts. Okay. It's just hard work. We can call that professionalism, but it is just hard work. Proofread, edit continuously. All right. That old cliche next, that old cliche, hope for the best and prepare for the worst. That's what a contract is. The first week of school, the first week of this class, maybe we should have defined a contract as hoping for the best, but planning for the worst. Okay. Hope for the best, but prepare for the worst is exactly what a contract is. The contract should define and guide your relationship. It should be a source document that the parties can always go back to if they have any questions about what their obligations are, if they have any questions of what their rights are. But it is also the roadmap that the court is going to use if everything goes south. If something goes bad, this is the document that is going to end up determining all the rights and all the obligations of the parties. So hope for the best, but prepare for the worst. All right. Now, let me give you a little bit of wiggle room there, right? Because of that, there is a tendency, you will find out pretty quickly, there's a tendency among lawyers to draft really long contracts that get unnecessarily complex and complicated. All right. Beware of doing that. I understand that you want to prepare for the worst. I understand you want to prepare for every possible detail. But consider, number one, obviously you have to consider the resources of your client, right? Is it worth a 50-page contract when a 3-page contract will do? But second, if a 3-page contract will do and you've drafted 50, have you made things clearer by worrying about every little possible minute detail? Or have you just made the contract more complicated? Have you created more ambiguities? Have you created more potential technicalities and loopholes? Okay, so always prepare for the best and plan for the worst, but understand that planning for the worst does not necessarily mean making it longer. Okay, make a contract so good that everybody understands what their requirements are and everybody understands what's going to happen if they breach it, so that you never have to go to court. The very best contract never sees the courthouse. Okay, that's the contract you want to draft, so that people can pick it up. They can clearly understand what their obligations are. They can clearly understand what their rights are, and even if they breach it, they know what the consequences are going to be, and they can take care of that right away. Right? Hey, I'm sorry. I'm going to have to breach the contract, but here's a check. Right? Or I'm sorry, I'm going to have to breach the contract, but here's what I'm doing instead. Maybe it's the UCC, right? I'm sorry I'm breaching the contract, but I'm going to send you some other type of non-conforming good and hope that you accept it. Or, hey, you've delivered a non-conforming good and I'm not accepting it, but let me remind you of your right to cover, right? Those kind of things. Draft a contract that's so good that it never sees the inside of the courtroom. All right. The last case is just this. Always remember to go back to the basics. Always remember to go to our first principles, that there are 4 elements to a contract: an agreement, meeting of the minds, consideration, and then we have that whole question about legality or capacity. Okay, an agreement, a meeting of the minds, consideration. You have to have those things: mutuality, capacity, legality. You've got to go back to those basics in every single contract. Even things like statutes of frauds. And does this contract need to be in writing? Um, you need to apply those to every single contract you work on. That seems so easy now because you've had one semester of contracts. But as you get down the road in negotiating and drafting and you've done 10 contracts or 100 contracts or 1,000 contracts, it's hard to remember to go back to first principles. And when we do, sometimes we lose the forest for the trees. I can't tell you how many contracts I've been involved in litigating that are simply not enforceable because the very experienced, very smart lawyer who drafted such a good contract, drafted such a tight contract that the other side had all the obligations and his client had zero obligations. The result was zero consideration. He was just so smart, he didn't go back to first principles. He drafted a contract that wasn't a contract. That's not enforceable. Again, take a look at that Donald Trump contract. They tried so hard to be so crafty about being confidential and about being sly about who are the parties and that kind of stuff. They ended up drafting a contract that was very expensive, but was completely worthless. It wasn't worth the paper it was written on. If anything, it was an albatross around their necks, right? It was a bigger problem than if they just had no contract in the first place, right? I mean, if Stormy Daniels had gone on every news station in the country saying, "Hey, I had an affair with Donald Trump," at least he could have denied it, right? Or kept his mouth shut. But when she went on every single show in the country saying, "I had an affair with Donald Trump and I've got a contract right here where he paid me not to talk about it," oh my God, that's worse than if you didn't have any contract in the first place, right? Now you're tied to that. It looks terrible. So that's it. First principles. Remember to go back to first principles. Remember to be clear. Remember to draft for a fifth grader, and then just be professional. Be meticulous, be diligent, proofread, edit, draft a children's book. If you can draft if your contract is as easy to understand as a children's book, if it's internally consistent, if it makes sense from beginning to end, and you can hand it to anybody you know, and they understand exactly what that contract is for, exactly what it will do, then it's a good contract. All right. That's it. That's all I've got for today. Or that's all I've got for this chapter. Now you all have a contract drafting assignment this week, I believe. And some people have already asked some questions about what do I expect that to look like, or what I want you to put in it. And I told at least one of you that honestly, what do I expect is that some of them will be real garbage. Okay, that's okay. I don't mean that you're not capable of drafting a perfectly good contract. I believe at this point that you all should be capable of drafting a pretty reasonable contract. I just mean that some of you are going to get over ambitious, and you're going to want to draft more than you can. You may draft something that I don't think is entirely enforceable, or that I don't think you entirely thought through, or maybe you don't know enough to think of all of the ramifications. That's okay. That is okay. The point of this exercise is I want you to draft your first contract. All right. Now, you can do it from scratch if you want to. I told you we draft contracts from scratch, but you don't have to. I also told you that I never draft contracts from scratch. I've always got something that I've done in the last 10 or 15 or 20 years that I can pull up and change and edit and use again. And if I don't, I can probably Google something or use Westlaw, right? Use the forms on Westlaw. Go over to the library and look at the Texas form books. You can always find some form out there, and that's okay too. Some of you will draft a one-page, automobile sales contract, something like that, and that's just fine. And you'll get, and as long as it looks good, you'll get 100%. Okay. Some of you will want to do more. Some of you will be interested because maybe you're thinking about buying a house soon, or maybe you just bought a house and you want to go get some of those TREC, the Texas Real Estate Commission forms, and you want to draft a residential home sales contract. If that's what you want to do, go use that TREC form. Fill out the parts that you think need to be filled out. Let me take a look at it. That's ambitious, but I'll bet you can do it, and you'll get 100% too. Some of you get crazy, and I've seen people try to draft a licensing agreement between Justin Bieber and your promotional company, or fictional contracts between Donald Duck and Mickey Mouse. That's fine. You draft what you want to do. Make it as complicated as you want to, but you don't have to. This is for your experience. If you just want to get the assignment done, do something quick and easy. Okay. My advice to you, though, is even if you want to do something quick and easy, draft something that you might use. Start that folder that I told you that you ought to keep on your computer, that folder with examples of contracts. Let's start that folder with your very first contract. What is it you want to do? What kind of contract might you need in the future? Maybe you don't know what you want to do. Maybe you don't ever want to work in law. Maybe you're just auditing this class. You'll still buy or sell a car, right? If so, find you a good bill of sale for a contract. See if you like it, massage it and make it yours. And then at least you've got one on your computer. If you're thinking about buying a house and you'll want to look over those TREC contracts, do that and keep it on your computer so that you've got a form. If you already work at a litigation firm and you've got one in mind, a settlement agreement. We draft settlement agreements all the time. 90-something% of cases never go to trial. They settle out. So draft a settlement agreement if you want to, but start your own form file. That'd be my best advice. Pick something that you want to do for your very first form and keep it. Okay. That's it. If you've got any questions, as always, give me a call, shoot me an email. If not, next week is your final exam. Check the information on eCampus about that, and I'll post a separate video about it. I'm also going to post a couple of review videos for the first half and the second half. I encourage you to go over those. If I'll go over some practice questions, I'll post some practice questions. If you can answer all the practice questions, then you can ace the exam. If you can't pass all the practice questions, then watch the review. And if you get it after that, if you understand everything in the review, you'll ace the exam. If you have tried the practice questions, you've gone over the review and you still don't understand it, give me a call, shoot me an email. Let's make sure that you understand it before your final exam opens up. Okay. But the dates, the calendars, the timelines, the deadlines, all that kind of stuff, those are on eCampus. Your final exam will open on a Thursday at 8 o'clock in the morning. It'll be due Saturday at midnight. So you've got, 3 full days, Thursday, Friday, Saturday. It's not timed. Take as long as you want. You may use your resources. I think we talked about this in your midterm exam. If you were a paralegal in my office and I asked you a legal question and you answered it off the top of your head, I'd throw you out of my office. I can't cite you to the judge. What good does that do me? Lawyers, paralegals, we're not lawyers and paralegals because we know the answers. We're lawyers and paralegals because we know where to find the answers and we make sure that we're finding the right answer. If that's the way I want you to practice, then that's absolutely the way I want you to do this final exam, right? So if you're not 100% sure you know the answer, should you use your resources? Absolutely. If you're 99% sure you know the answer, then you're 1% unsure. Look it up, okay? The only thing you can't do is talk to your friends. That's cheating, and when that happens, I got to turn you into the school, okay? Use your resources. What resources? Your book. Use your book and use your notes. And use my class notes and look up the PowerPoints in this class and watch the video lectures if you want to and Google it. Can you use Google? Yes, absolutely. I'm not making you use a lockdown browser. Can you use Westlaw? You shouldn't need to, but if you want to use Westlaw on your final exam, you use Westlaw you got 3 full days to use Westlaw on your final exam. Okay. Get every single question 100% right. Your final exam is liable to reflect your effort more than how smart you are. Okay. Maybe even more than how prepared you are. Preparation, certainly part of it, but it will absolutely reflect how hard you work on the exam. You've got 3 days. Will it take you 3 days? No, nobody has to be scared. And that's really where your preparation comes in. If you haven't been keeping up and you're half a semester behind, it may take you a while. You may need the better part of 3 days. But if you've kept up with the work, if you've studied, if you've looked at the review questions, no, it shouldn't take you. Some people may get it done in an hour. It's not fair. I can do it in about 12 minutes, but I made up all the questions that I've taken it before, right? I guarantee you, though, if you're prepared, some of you will get it done in less than an hour. But if you get it done in less than an hour, don't turn it in. Save it. Check your answers until you're 100% certain. That's what I want to see you guys do in this class, okay? Everybody can ace this exam if they want to. Even if you've fallen behind, you can ace this exam if you want to. It's going to be a matter of effort. Once the exam opens, no more questions. I can't be answering emails and questions about hypotheticals. Once your exam starts, it's just not fair to anybody, right? So once it opens on Thursday morning, next Thursday, right? Check your calendar. I can't answer any more questions, but that means until then, ask me any question you want. Take a look at those review questions. And if you have any questions, let me know. All right. Otherwise, that's getting it. That's about it. We're getting pretty close to the end of the semester. So again, last time, any questions at all about this class or quite frankly, about any of your other classes, give me a call, shoot me an email, write me a text anytime. Okay. Otherwise, that's it for this week. And the next time I'll see you is in a final exam review. All right. Have a great week, guys, and enjoy the rest of your week. I know a lot of people have special things going on. So if you have a great time, that's why your assignments are short this week. Don't hate me, but at least it's not too much. Okay. All right. Have a great week.